Good morning, my friends. Law of the Land, Part 7, 26th of January 2018. And we are going to continue with LORE, Law of the Land. One of the things that you must always remember is this. And I'm particularly addressing this to our friends in Spain, our friends in Hawaii, our friends in Aotearoa, and the tribal governments in Australia. When you are dealing with the law, the door please, yeah, thank you. When you're dealing with the LAW of the land, you're dealing with Anglo or Anglo-American jurisprudence. In other words, you are attending to your legal issues based on their baseline, based on their templates, based on their beliefs, values, opinions, and views. Your chances of winning based on LORE are at best slim, at worst none. You can never prevail. That's the basic truth about the LAW of the land, an imported version of the truth. Like they have a monopoly over the truth. Now, let's take the example of the Kingdom of Hawaii. We all know how Queen Liliuokalani lost her kingdom because of a stupid sugar tariff. All right, all these businessmen had contacts in the U.S. Senate, and they were able to get the Marines to come, a show of arms, and the Queen decided there shall be no bloodshed. Therefore, she did not resist. So the Marines took over. They call it an occupation, an annexation, if not an invasion, and they made Hawaii their territory. See what I mean? When you got a bigger gun, you can do what you like. Arma in armatos, sumere jura sinunt. The taking of arms against the armed is allowed in law. Now this is the law, LAW, that those guys imported and shoved down our throats. So why are we that stupid that we can't use their law against them? Like jurisprudential judo. You know why we don't do that? I'll tell you why. We have got this perennial malaise, this perennial endemic disease, if not an epidemic, called fear. Look, if you have a love affair with fear, this is not for you. Turn off your video and don't even listen to what I have to say. I am talking about how you can get your own sovereignty back using the law of the land, LORE. You cannot use the LAW. It is an imported poison. It's like contaminating your streams and your source of life. That's what the LAW of the land is. Now, it is said that law, which is the shoots, come from the roots of LORE, law. Coming back to Hawaii. Article 12, Section 7 of the Constitution of the State of Hawaii says this, that your ahupua'a, right to customary usage of your lands, shall not be abridged. That is in the Constitution of the state of Hawaii. Article 12, Section 7. Why don't you guys check it out? You don't have to be a lawyer or a judge or a legal scholar or a law professor to figure that one out, because that gives you the right to police power, to your own parliament, legislature, to your own executive. Re-establish the kingdom and your own judiciary. And under Article 1 of the Montevideo Convention, you are already a nation state. The Kingdom of Hawaii, in the good old days, had like 57 or 68 treaties with all countries in the world, including Japan, Germany, France, England, US. Rejuvenate the treaties. And I believe there are 7 kings and queens in Hawaii. Come together, people. You can't have a separate kingdom. United, you stand. Divided, you fail. You fall. All right? Take a message, Tanti. So, remember, you have no hope with the law of the land, LAW. But you have faith and belief and values in the law of the land. The law of the land is the currency of this realm. There is nothing else more genuine, more valid than your law, L-O-R-E. It's the same for Aotearoa. It's the same for the tribal governments in Australia. It's the same for any and every tribal government in the world, and applicable South America, North America, Kingdom of Hawaii. All right? The moment, and this is for the Kingdom of Hawaii, the moment you fight them in their courts of law, you are finished. Now, going to the International Court of Justice for Human Rights, that's all well and good. But you go there after you have found favor in your tribal court. If you look at 25 U.S.C. 1152, 25 United States Code 1152, what does it say? If you're already tried in an Indian tribal court, you're not eligible to be tried again. Check it out. You lawyers, judges, professors of the law, 25 United States Code 1152. Take me on. Come on. Live debate. No notes, no teleprompter. That's it. Those kinds of notes, which is what I'm going to be talking to you about very, very soon. So, use your law. And for the Kingdom of Hawaii, let me tell you this. Your LORE of the land is already entrenched, embodied, encompassed in Article 12, Section 7 of the Constitution of the State of Hawaii. Your ahupua'a right to customary land. Hell, every piece of land, every inch, every drop of sand in Hawaii enjoys ahupua'a right to customary land. What are you doing about it? Quit looking at their law, LAW. Concentrate in what the first King Kamehameha set up as your tribal code of conduct. That is your whakapapa. That is your wakaputanga, like the Declaration of Independence in Aotearoa. They had already planned the future. Why did you let the Pakia, why did you let the European come and tell you how to lead your lives? Can you invade Europe and tell them how to lead their lives under Hawaiian or Maori standards or Native American standards? What do you mean you can? Of course you can, but you don't have a bigger gun. Have a sharper mind, a bigger mind. concentrate in LORE, game over. Now, having said that as an introduction, all right, remember, you cannot, will not ever win in their courts of law, LAW, where they use the English common law. I am an advocate for law, LORE, that was based on common sense. Hell, if I'm not mistaken, there was a fellow called, what's his name, John Payne? Yeah, Paine, who wrote a book called Common Sense, way before the revolution. It's one of the books that got, no, Thomas Paine, I'm sorry. Thomas Paine, Paine, Common Sense. Read it. You can Google it. Look what he says there. Common sense. The law, the lofty ideals of the law have to start at the roots with common sense. The embellishments and the accoutrements can come later with the shoots to make it look nice. If the roots are not strong, it's like our Lord Jesus, the risen Christ, who cursed the fig tree that seemed to be in full bloom. It bore no fruit. All right? So, let's curse the shoots that do not represent the roots, and let's uphold the roots. Bless the roots with the sustenance of belief and faith that will strengthen the roots. Once you are on terra firma, that's Latin for firm ground, solid foundation, you are unshakable. Nobody, nothing can shake you. Bible says you don't need faith as big as a pomelo or a coconut. You need faith as small as a mustard seed. Bible is full of allegories, metaphors, parables. Don't take it literally, like some idiots make fun of the Immaculate Conception. They make fun of the talking snake. Well, that's looking for cheap laughter. I can milk the stupidity that you guys out there calling yourselves government, devil, I can out-laugh you guys and out-think you guys when you think you got the monopoly on laughter and humor and wit. Look at God's ultimate humor. Huh? Look at the way He made this. Look at the way He made you. Huh? Nice, huh? Well, you can laugh about that. Now, common sense and the law of the land believe not in views and opinions. They believe in what the Almighty Creator set as a standard. That standard is not open to a view or an opinion. The truth is not subject to interpretation. The truth is subject to faith, belief, application, judgment, commitment. All right? Now, let's talk about a value judgment. Now, let's take Roe versus Wade, which in 1973 literally legalized abortion, provided the mother's life was not in danger. And I'm not sure if they said this, but I hope they said this. I doubt they said it, but provided the mother's life and the child's life is not in danger. So if the mother's life, the conceiving mother, and the concepted child are not in danger, why the hell do you look for abortion? Aha! Caught you there. So they said abortion is okay, provided it is not after, I think, the third trimester or something. Now, the view and the opinion on Roe versus Wade throughout America was that a woman has a right to privacy and how a woman decides what she wants to do with her body. Now remember, my mother is a woman, so is my wife, so is my sister, and so is my daughter, and so is my mother-in-law. All right? Don't get me wrong. The opinion and the views of the woman did not create the value judgment of the Supreme Court of the United States when it declared in a 7-2 majority that abortions can be legalized. I hope you understand the difference between a view, an opinion, and how a view and an opinion can become a value judgment. Now, Henry Bracton, William Blackstone, whose books formed the basis of law, LAW, in the colonies in the United States, they said life, as we understand it, begins at conception. Therefore, that embryo is a person. In Roe versus Wade, one of these stupid Supreme Court judges was grappling, struggling, meditating, arguing with himself about whether a fetus is a person. But they all studied law based on Henry Bracton, William Blackstone, and Lord Coke's works. Francis Bacon was all imported into the colonies, the 18th century. In fact, Blackstone's commentaries on the law was the major source of all law in the colonies. So Roe versus Wade is a perfect example of a value judgment that was based on public opinion, public view, public policy, and a segment of society where women wanted the right to privacy. You remember, I always said in my law classes, in any case, there's only one issue. What do you think was the issue in Roe versus Wade? Right of privacy of women, which is not guaranteed in the Constitution anywhere. The Fourth Amendment says reasonable searches and seizures. Therefore, unreasonable searches and seizures are not allowed. So where's your right to privacy? Value judgment. Now, let me talk to you about the difference between a value judgment and a value commitment. A value judgment, if it's based on the right thing to do, not the popular thing to do, based on common sense, and based on the Word of God, and based on scriptural power, when you obey and apply that norm, that becomes a value commitment. It is beyond a value judgment, an opinion, a view. It is a judgment which has got the force of commitment and applicability. IDEA. Identify the issue. Define the issue. Describe the issue. E. Examine, evaluate the issue. A. Apply the action to the issue. So now, when you make a value judgment based not on views or opinions, hey, opinions are just like noses. Everybody has one. Yeah, big deal. But a value judgment, not everybody has one. If you got a value judgment, it is based not just on logic and reason. Remember, reason is defined by a great thinker, at least in my opinion. Reason is the most naive of all superstitions. So reason and logic can be faulty. Instinct, like animal instinct, cannot be faulty. A dog, an animal, a wild animal, it knows. Can smell trouble, can smell gun oil, it can smell fear. So, my friends, when you apply the LORE of the land, and this is part 7, the law of the land, remember to apply common sense so that we get a value judgment, a value commitment, which will then escalate to a value application. Otherwise, this house of cards will come tumbling down. There is no meaning, right? There is no meaning. It's got to have meaning, all right? It's got to have power, and it's got to have application. So for the Kingdom of Hawaii, I say to you, walk away from their LAW. Use your LORE, starting from your Article 12, Section 7, rights to ahupua'a, rights to customary land. Use that. All right? Until we meet again, this is Naveen Chandra Naidu signing off. 26th of January, Friday, 2018, and I'm going to be playing golf in a little while. God bless you.